There is no greater form of consumer protection than fostering competitive, innovative, and transparent markets, and then vigorously policing them for fraud, theft, and deception. In policing our markets under Mr. Cordray's leadership, CFPB's success record is anything but clear. What is clear, though, is that under Mr. Cordray's leadership, the CFPB has shown an utter disregard for protecting our markets and has made credit more expensive and less available in many instances. This is particularly true for low and moderate income Americans. What is also clear is that under Mr. Cordray's leadership, the CFPB has acted unlawfully, routinely denied market participants due process, and abused its powers. The CFPB has now finalized a rule that would reduce access to prepaid card products, harming nearly 70 million consumers who do not or cannot use traditional banking services. Thanks in part to CFPB's oversight, credit card rates have risen significantly, with many would-be borrowers being priced out of the market entirely. Many credit-worthy borrowers could pay almost $600 more for their auto loans due to CFPB's indirect auto lending guidance. On March 31, 2013, CFPB issued Bulletin 2013-2, attempting to impose control over dealer indirect auto lending compensation. In doing so, CFPB sought to illegally regulate companies over which it has no statutory authority and which, in fact, are expressly exempt under the Dodd-Frank law. CFPB then failed to afford due process to regulated companies under the Administrative Procedures Act. For conducting unlawful activities, abusing this authority, denying market participants due process, Richard Cordray should be dismissed by our president. Not only must Mr. Cordray go, but this current CFPB must go as well. American consumers need competitive markets and a cop on the beat to protect them from fraud and deception. They don't need Washington elites trampling on their freedom of choice and picking their financial products for them.
Mr. Director, in past hearings in the committee staff reports, we've alleged that the true purpose of your indirect auto activities was to regulate auto dealer compensation, over which you have no jurisdiction under the Dodd-Frank Act. The Campbell-Brownback Amendment could not have been more clear in that. You've always testified to the effect that of saying that you are only addressing lenders and that you're careful not to step over that line. Yep. But we now know that right. Answer is hogwash. You may ask, how do we know this? And well, because we have your documents, Mr. Director, I want to enter into the record a document dated July 9th, 2012, entitled, and I quote, "Notes from the Auto Finance Discrimination Working Group, attended on behalf of non-bank supervision by Callie Bracey," end quote. Mr. Director, this document has not been previously released by this committee. It contains a detailed summary of the second ever meeting of a special working group put together to discuss direct auto. According to this document, the working group was chaired by Patrice Ficklin and Rick Hackett. The document describes the Bureau's preliminary research efforts, and then comes the smoking gun. The document says, and I quote, "To figure out what to do to prevent disparate impact, the thought is that we should eliminate dealer markup," and I end quote. So, Mr. Director, there you have it. Notwithstanding your prior testimony, the operating theory behind all your agency's indirect auto efforts from the beginning has been to quote, and I quote again, "eliminate dealer markup," end quote. Mr. Director, aren't you alarmed that your agency planned to regulate dealer compensation in clear violation of the law?
No, I think there's several things that aren't correct about that account, okay? First of all, and you're referring to a document from 5 years ago. I'm not familiar with it offhand, but I will say this.
We'll make sure you get a copy of it. It's from your office.
We have never taken any enforcement or supervisory activity against any dealership unless they were buy here, pay here, which is within our jurisdiction. We've been very careful to observe that line, but we do have responsibility over auto lenders, and we had the dilemma of how to deal with that responsibility when, in fact, they and dealers often work together.
That's not what this document says. Again, it says the intent here is to say that. Let me keep
but
moving on. I've only got a minute and a half left.
If I could.
Other people have 10 minutes. I've got 5. According to the other Bureau documents, on May 20th, 2013, you held a meeting with your senior staff in preparation for which a briefing memorandum was circulated stating the meeting's purpose was to, quote, to continue discussion around a market tipping settlement that would resolve the discriminatory practices caused by dealer markup by eliminating markup at many major automotive dealers, end quote. Do you recall this memorandum?
I don't offhand, but that would refer to dealer markup as part of lenders'
Well,
lending
again, we'll provide
programs.
that to your staff, and we actually did provide it to your staff ahead of the hearing to help you refresh your recollection. We also released it publicly as part of our staff report in 2015. At the time, your bureau was pursuing a consent order with Ally, isn't that right?
We did pursue and conclude a consent order with Ally. I'm not sure exactly what time frame you're referring to.
Yeah, well, your own bureau documents say that you were, on October 7, 2013, a draft decision memorandum states that your bureau sent Ally a proposed action response
Yeah,
request
that's-
letter informing the company
I don't
that an
dispute
enforcement
that.
action was likely on January 15, 2013. Director Cordray, your bureau reached its indirect auto lending settlement with Ally at a time when it had unprecedented leverage over Ally. At the time, Ally had an application pending before the Federal Reserve for status as a financial holding company. The CFPB sent notice of its intent to bring an enforcement action against Ally on January 15, 2013. Ally would have to divest its insurance and used car remarketing operations if the Federal Reserve did not approve its application for holding company status by December 24, 2013. At the same time, the FDIC was conducting a Community Reinvestment Act review of Ally. Your staff drafted a decision memorandum dated October 7, 2013, showing that your bureau was fully aware of the implications of this. I think there's real problems here, again, using authority at a time to force auto dealers and to push an agenda.
Now,
My
if-
time's
if I-
past expired. I yield back.
If I could, can I?
Please.
Okay.
Briefly.
When we bring an action, we always hope to resolve it on appropriate terms. Sometimes the institution is not willing to resolve it, and sometimes they are. That's up to them. That's a choice they make. That was a decision that they make. It's not a decision that affected, that involved dealerships. We've never brought an action against dealerships that are not buy here, pay here. That's not within our jurisdiction. It is the case, it's an unfortunate thing in this market, that lender programs and dealer programs kind of intersect. And
What
you
bothers
can't-
me is the
Gentleman's time
agenda
has
that's
expired.
stated
Gentlemen.
and using power to force, again.
Gentleman's time has
I
expired.
don't think that's,
Thank you, Chairman Hensley and Director Cordray. I'm going to forego any opening remarks that I might have this afternoon and get right down to business.
okay.
I think you know by now that I am still a car dealer in Texas.
I didn't know you still were, but I knew you had that extensive background, yes.
There you go.
Very
I
successful
got
one
it.
is what I hear, so.
Thank you.
yes.
We've talked about this numerous times. After listening to some of my testimony today, I'm kind of starting to think you don't have much respect for my profession. But I'll
No.
get back to that. And the family who needs $100 for a simple car repair. In the end, one way or another, those consumers will be hurt. So going back to auto lending real quick, I have a form right here the CFPB and the DOJ sent out to customers they felt were discriminated against when purchasing a car. So I want to ask you a quick question here about that, yes or no. Can the Bureau decide if someone has been discriminated against based on an account number?
Based on account number?
Yeah,
No.
okay. Can the Bureau decide, okay, Mr. Chairman, my time's out.
Could I just have a
Time-
word? 'Cause-
time-
Kind of a point of privilege, if I could, just because the
Well,
suggestion was that I don't have
I'm
respect for car
sorry,
dealers. Congressman Williams, I have a lot of respect for auto dealers. I worked with them closely in Ohio when I was Ohio Attorney General. We went through the financial crisis, and a lot of them were teetering. We went through the GM bankruptcy. We went through the Chrysler bankruptcy. There were a lot of dealers who were going to lose their dealerships, and I fought for extra arbitration to get a lot of them saved. The auto dealers know the work I did on their behalf. I worked closely with them in handling complaints, gave them a chance to handle them before we took any actions against them. So you can talk to my friends in Ohio, and they would tell you that I do have respect for you and your profession and all of them. That doesn't mean we don't have a job to do here, and I try to do it faithfully.
You're getting to the end of the line here. I just would like to just refocus a little bit. I'm a small business owner. I come from a community that's been devastated by a poor economy. In fact, in many areas of my district, we're ranked dead last in the national economy. And my concern is over, obviously, regulations, and a lot of the regulations dealing with the auto industry. And I noticed in your comments from last winter that the Bureau dropped its Equal Credit Opportunity Act lending enforcement for fair lending priorities list this year. These enforcements, in my opinion, were flawed auto financing guidance process issued by the CFPB, and it also barred consumers from participating in this process and commenting on it, and created a lot of uncertainty in the $905 billion auto lending market. And my question is going to be, why did the Bureau pull out of this this type of financing guidance, and why, at some point, why was that a decision made by the CFPB in your directorship?
So we didn't pull out of that guidance. That guidance merely, as we understood it, restated existing law and didn't add anything to it. What we did say is we have a fair lending program. We have limited resources. We set our priorities every year. And at this point in time, we were determining priorities for 2017, and we specified that they would be redlining, mortgage and student loan servicing, and small business lending. And that
Let me reclaim my time and get back into the auto industry, because that's what I would like to refocus.
Yeah.
In effect, what you're doing is, in my view, it looks like you're taking the financing industry and trying to, circumvent the Constitution and go at the auto dealers without having really the authority to do that, is coming in on the financing side of the, I don't see how you can justify that, and so I'm just surmising that you pulled out because you realized there was an overreach constitutionally on this issue.
First of all, that's not what we're trying to do, and that's not what we did here. The statute, Congress drew it, not me, says that we have no jurisdiction over auto dealers. But it says we do have jurisdiction and therefore responsibility to deal with auto lenders. So how do you do that? It doesn't work very well, I will agree.
Let me reclaim my time and ask you, aren't there other agencies in government that are regulating the auto industry, including on the state level, such as New York State, which has a very aggressive regulatory scheme to help consumers with the auto dealers? So to me, it looks like, wouldn't you agree that it's an overreach for the federal government to use the lending process to go in and go after an already regulated field?
Yeah, we haven't gone after any auto dealers other than buy here, pay here. The FTC has that authority, and they will exercise it or not as they see fit. I don't have that authority, but I do have the authority and therefore the responsibility, the duty to deal with auto lenders, and the two get in each other's way. That's an unfortunate way the statute was drawn. But in terms of
hold on a second.
In terms of our decision
Let me reclaim
now,
my time and say it's an unfortunate way the statute was drawn. So are you outside the statute and trying to pursue your lending against the auto dealers?
No, if we pursue auto lenders...
It wasn't withdrawn the way that you wanted it drawn, so you created your own...
No, not at all.
Right.
We have a responsibility to pursue auto lenders. That's going to affect auto dealers. I can't help that. That's the way the market is. Either we should have had both or we should have had neither would have been a better way to do it.
Right,
But,
so you're conceding then that the statute wasn't really the way it should have been, so instead you use the lending mechanism to get into the dealers.
Not at all.
Right.
It means that as we do our job, people are going to be able to criticize us because it has consequences and ramifications down the line. But in terms of specifying our priorities for this year, as you noted, auto is not among them, and we indicated that we have proceeded with different supervisory enforcement actions against 20 of the largest auto lenders. We will continue to supervise around this, but that we needed to look at other priorities as well. So that I think was a sound judgment that we had to make.
So couldn't let me reclaim my time and say, wouldn't you concede that, you withdrew from having this as a priority program, so now you are using the regulatory process with lenders to try to reach into the auto industry?
Well, I'm not trying to reach into anything. I'm just trying to do the job Congress gave us. And if
but you just said the job Congress gave you, but you just said a moment ago that Congress didn't have that in the statute the way you needed it, so now you're kind of...
No, not the way I needed it, just Congress did it. I don't think it's very logical, frankly, to give somebody responsibility for auto lenders but not auto dealers or vice versa.
Right, so you're conceding that the statute really doesn't cover the dealers, so...
We've never taken an action against dealers. We've never done that. But it doesn't mean that things we do might not affect dealers. Just like if the Federal Reserve raises interest rates, that's going to affect dealers, but they're not regulating dealers.